Welcome to Motivation at Hand. To know is to know how. Make your foot the foot that counts. In New York's courts, a tale unfolds, where justice's hand, firm and bold. Trump's empire faces its sternest test, as legal battles put to rest. Judge Engoron's gavel strikes the air. In a 92-page decree laid bare, the lawsuit outlined 7 allegations of illegal conduct, ranging from persistent and repeated fraud to conspiracy to commit insurance fraud. These claims primarily revolved around inflated property valuations provided by Trump and his company to banks and insurers. Affirmed by the judge in his order, the legal action delineated 7 grounds for legal pursuit, representing illegal conduct according to common law fraud. This instant action is not a garden variety common law fraud case, which they argued entitled the New York state to reclaim illicitly acquired profits and necessitated imposing significant penalties on the defendants. Common law fraud, also known as misrepresentation, has 5 elements. 1. A material statement. 2. Falsity. 3. Knowledge of the falsity, scienter. 4. Justifiable reliance. And 5. Damages. Persistent and repeated fraud. Falsifying business records. Conspiracy to falsify business records. Issuing false financial statements. Conspiracy to falsify false financial statements. Insurance fraud. Conspiracy to commit insurance fraud. In a landmark decision, Judge Arthur Engoron delivered a 92-page judgment on Friday, imposing one of the largest corporate sanctions in New York history on former President Donald Trump and the Trump Organization. The ruling mandates Trump and his organization to pay $354 million in fines, a figure escalating to $453.5 million with prejudgment interest, in their New York civil fraud case. This ruling also entails a 3-year prohibition on seeking loans from financial institutions in New York and a corresponding ban on Trump serving as an officer or director of any New York corporation. Trump has expressed intentions to appeal the decision. Attorney General Letitia James initiated the civil suit in 2022, originally seeking to bar Trump from conducting business in the state and proposing a $250 million penalty. By the trial's conclusion, James' office had increased the penalty request to $370 million. Trump and his legal team anticipated an adverse outcome, consistently denouncing the case as rigged and a sham. Engoron had previously ruled in September that Trump and the other defendants were liable for fraud based on evidence presented during pretrial proceedings. The trial, commencing in October and concluding in January, delved into allegations including falsification of business records, issuance of false financial statements, insurance fraud, and conspiracy. The financial penalty, termed disgorgement, aims to recoup the gains Trump and his company accrued through the fraudulent scheme. Former Trump allies, including Weiss Selberg and Michael Cohen, testified during the trial. Cohen admitted to his and Weiss Selberg's involvement in manipulating asset values to meet Trump's desired financial targets. Weiss Selberg, however, claimed he couldn't recall discussing the financial statements with Trump. The judgment criticized Trump and his associates for their lack of remorse, emphasizing their conduct's detrimental impact. Trump et al. Have 30 days to appeal. What will be the deal? 3 years barred from loans, a stern decree. Trump's empire faces a financial spree. But where will he source the funds to bind? In the realm where legal battles win? With coffers strained, and options few, the path to appeal remains askew. From distant shores or assets sold, the means to continue, yet unfold. Much appreciation to you for giving of your time with us at Motivation at Hand. To know is to know how. We trust you will come back soon.